Welcome to the Rental Act in 3 Minutes with Offit Kurman. I'm Robert Donahue with the DC Landlord Representation Group.
And I'm Brian Dorwin.
Today we're talking about pleading technicalities. Now, prior to the passage of the Rental Act, the state of the law was that the court must, or rather shall, dismiss cases that carry those defects. So any problem with any element of your case or any document attached to your case could result in a dismissal at any point, whether that be at the initial hearing or the day of an in-person jury trial a year down the line. This is, of course, very disruptive when right before trial you learn that there won't be a trial and you need to start from scratch. Passage of the Rental Act has changed that radically, and it's restored judges their discretion. Now judges have a choice. They can view the record and examine whether this actually creates a prejudice or a harm and dismiss if that's necessary, but they aren't required to anymore. For our clients, this means that minor defects in, for example, a 10-year-old RAD form aren't fatal. They don't result in the refiling of your case. This allows our clients additional time to correct these issues, sometimes in parallel with the case being filed, and doesn't cause them to have to start from scratch.
The Rental Act changed an important part of the eviction statute from shall to may dismiss. Now the language reads, if a notice isn't issued consistent with this section, the court may, when weighing the prejudice to all parties, and in its discretion, dismiss the case or permit leave for the complainant to amend. This is an incredibly important change. Those minor technical details which used to sink a case on the first day, or even more frustratingly, on the day of trial, after waiting for 18 months, are now within the court's discretion to consider and make a common sense decision. This means we can argue and advocate for you more effectively in court because judges are not compelled to dismiss a case based upon incredibly minor technicalities that may have existed in the paperwork for decades without you noticing. It's also important to mention that this will result in fewer cases being refiled to correct these minor technical deficiencies. On balance, this is an incredibly important development in the law, and we hope that we'll be able to advocate for you more effectively given this important change of the Rental Act. Thanks for joining.